Hello and welcome to our latest video update, and it's quite an important one. On the 11th of September 2024, the government introduced the Renters' Rights Bill into Parliament. It's still very early stages with the bill, but given it was a big pledge from the Labour Party during the general election campaign, it's expected to move quickly through the various parliamentary stages. And the Housing Minister said in an interview with the BBC that he hoped the framework would be in place by early or mid-2025.
As we've said before, there are similarities with the Renters Reform Bill that almost got through under the previous government, and this one has been respun and recycled to fit the new narrative. We've taken a look at the guidance, and while there aren't any huge surprises based on what we expected, there is still quite a lot to take in, and the changes it will bring will be the biggest within the sector for more than 30 years. In our video today, we're going to offer an overview, but by no means exhaustive look into the bill. It would be impossible to cover every scenario, but we will send out a Google form for any feedback questions, which we can then raise with Property Mark for lobbying purposes or seek clarification for you. We've also included a link to the guidance so you can take a read yourself and enjoy reading through it.
Let's get started with notice and possession. The big one for many landlords will be the removal of Section 21 as a means for gaining possession of a rental property. This method for getting possession will no longer be possible under the new rules. All tenancies will be periodic, but there will be a protection from eviction for a period of 12 months after the tenancy starts. This is for tenants. This will essentially rule out winter lets for landlords that may use a property over the summer and may rent for 3 to 8 months in the gap.
However, the current wording of the bill, there is no minimum period that tenants are expected to stay. The notice period from a tenant to landlord has been increased from 2 months to 2 months, but in theory a tenant could serve notice on the day that they move in and leave 2 months later. This doesn't seem fair, and I have raised this point with Property Mark, who are going to be representing the industry in talks with the government and various other stakeholders, and I'm sure I'm not the only one to point that out.
To get possession, a landlord would need to follow a Section 8 procedure, which, like Section 21, involves a prescribed notice but must be under certain grounds. Currently, there are 8 mandatory grounds for possession, including a tenant being in at least 2 months' worth of arrears, and 9 discretionary grounds. Under the bill, this will be increased to 25 mandatory grounds and 11 discretionary. 4 months seems to be now the general default period for notice rather than 2 for landlords, and after the bill came out last week, we also sought clarification from Property Mark on their understanding of the 12-month protected period. They've told us that it is 12 months inclusive of any notice period, but not 12 months plus a notice period, which would have made a minimum term of 16 months.
We won't go through them all, but to give a few examples, if a landlord or a member of their family wanted to move back into their property, then it would be 4 months notice. If the same landlord wanted to sell, then they can't for at least 12 months, but you can start the process for getting possession in month 8 by serving notice. For students, it seems like you can serve within the 12-month protection period so that a property can be let to a new group of students in line with the academic year. This would always also be 4 months notice to students, so landlords would need to think about when they should serve that to their groups. I think the default position would be that students would not be moving out at the start of a tenancy, but in reality, of course, that's very different, and I imagine that will also be lobbied upon by the industry.
For rent arrears, the threshold for arrears will be increased to 3 months and the notice period extended from 2 weeks to 4 weeks. This would mean that in theory, a landlord would be without rent for 4 months before they can even go to court for a possession order. As in the current system with any of the mandatory or discretionary grounds, if a tenant does not leave, the landlord will need to go to court and they will need to provide evidence that the ground applies. Of course, if a tenant voluntarily moves out and surrenders the keys, then court or further action may not be necessary.
However, all landlords in the private rented sector will need to become members of a landlord ombudsman, the idea being that the scheme can mediate issues between landlords and tenants, lessening the need to go through the courts. Not sure it works in all circumstances, but the Renters' Rights Bill does make provision for the Ombudsman to provide landlord-initiated mediation, and there's not much detail on that at present. There will be a landlord cost to register, and local councils will be able to take action against landlords who fail to join or against anyone who markets a private rented property where the landlord is not registered. Similar schemes operate in Scotland and Wales, and agents have also been required to become members of a redress scheme. So the introduction of that is an extension, and I would believe there would be some crossover between the two in certain circumstances.
The other thing to bear in mind with a lot of the proposed changes under the bill is that the government plan to introduce the changes at one set point. So for example, let's say it's the 1st of June 25. From this point, all current and existing tenancies will be affected. All existing tenancies will swap on an assured tenancy rather than ASTs and will be governed by the new rules. In the past, changes have often been staged, like with the fee ban and EICRs, but not this time.
The bill will also introduce a new private rented sector database. All landlords of assured and regulated tenancies will be legally required to register themselves. This is being designed to help landlords understand their obligations and demonstrate compliance. The database will also be used for communicating changes to requirements. The database will provide local councils with more data about the private rented sector. Landlords in breach of a duty to register on the database will not be able to get a possession order. With this being the case, Property Mark is calling for the removal of selective licensing areas. Full details on what will bring are quite light, and the government have said that they are committed to carefully balancing landlord privacy concerns with private tenants' needs to make informed decisions about their housing options.
Moving on to rent, some other significant factors that have come out with this bill are rent increase notices are to be increased from 1 to 2 months. They cannot be above market rent, and there will remain tribunals where tenants can challenge rent increases. The market rent is defined at what the property could achieve if the property was going back on the open market. Landlords and agents are not allowed to ask for more rent than the property is offered for on the open market. I think in reality, in our experience, that is somewhat different to high demand areas in, say, London, where people have been encouraged to bid on rentals. That said, it's not clear if the tenant will make a free will bid on a property if, say, it's particularly desirable to them.
Some landlords ask for extra rent if a pet is requested. It's not clear if advertised on the outset whether this would be allowed or not. Incidentally, the bill also says that landlords will not be able to unreasonably withhold consent for pets in rental properties. Landlords would be able to take out pet insurance for which a tenant will be able to be charged. This will become a permitted charge under the Tenant Fees Act. Before anyone panics, in a flat, a head lease restriction would be deemed to be reasonable to deny permission, so we would recommend checking your lease now to ensure that you're clear in advance. There's other stuff too in the bill which covers the Decent Home Standard and extending Arab's law into the private rented sector, but this is extending the responsibilities of landlords that meet good standards of accommodation that most operate in anyway. We will look to cover this in the future at some point. But that's kind of a long but difficult summary of the renters' rights bill. So
there's a lot of that which is, as we say, just a spin-off of what we were preparing for anyway. So there's a lot in there which we're not particularly concerned by or shocked by. There's a couple of little additions in there, like the notice periods, which are a little bit more concerning. But as we say, it's not in law yet. And this will be discussed and lobbied probably quite heavily.
There'll be amendments, I'm sure, but I think the power of the majority that the Labour Party have got at the moment would see that. I think that most of this will go through pretty much unscathed. I think it just depends on what amendments are tabled, and I'm sure that the industry, so people like Property Mark and the NRLA will be putting amendments in or lobbying to try and get certain things changed within it. But we are. We knew it was coming. I think we just had to adapt as we see, we'll take it as it comes.
Yep, and we'll keep you updated as we hear more. We'll do another video as we hear any kind of more significant or major news, and we'll put that out in a newsletter. But do remember that we are going to attach a Google Doc where you can put any concerns or queries, and we can raise that on your behalf with Property Mark, who and then will kind of represent that at a higher point.
Okay, great stuff. Thank you very much, guys. We'll see you soon. Cheers.